Okay, first of all, what exactly is a work made for hire? And I'm going to be referring to it simply as work for hire. So a work for hire is simply a work that has been created by an employee within the scope of his or her employment, and the work has been created on the request of an employer in the course of employment. And please note the fact that I said within the scope of his or her employment, which means that the work must have been created in the course of employment. So who is going to own the copyright in that work? Well, first of all, remember always that the general rule is that the person who creates a work, that is the person who is the original author of that work, is going to own the copyright in that work, but there is an exception to it, because I said that this is a general rule. So the exception to the general rule is that if the employer and the employee have entered into a separate agreement which covers the question as to who is going to own the copyright in the work, then in that situation the agreement is going to be given priority. So one possibility is that the agreement may state that the company is going to exercise the copyright in that work by way of an assignment. That is, the author of the work will assign the right in that work to the company, or if it's not a company, it's simply a business, then to the employer, whoever that is. So that is one possibility. The other possibility is that the employer or the company, whoever the employee is working for, is going to be considered as the author of the work because of the fact that the work was created in the course of employment. So in this second possibility, the agreement is not saying that the author of the work is going to voluntarily assign the work to the company or to the employer, but instead the agreement clearly states that whatever work is created in the course of employment is automatically going to be the property, that is the intellectual property of the company or of the employer. So in short, always remember that whatever has been expressly agreed between the parties, that is between the employer and the employee, is going to be given respect and priority when deciding who is the owner of that work. Once again, I repeat that generally what happens is that the copyright in a work initially is always going to rest with the author of the work who created the work, that is. But work for hire is an exception to this general rule, where sometimes the employer or the company is going to be considered the legal author of the work, even though the original author, that is the factual author of the work, is going to be the employee. So the copyright of such a work is going to rest with the employer and not with the employee. And one point that I'd like to add here is that the same rules don't apply for works that have been created by independent contractors or by, for example, consultants. The topic of this particular lecture is to deal only with the cases where the work has been made for hire and not by consultants. But let me just tell you very quickly that usually if a work has been created by a consultant, then the consultant will have the copyright in that work, and the client for whom the consultant has created that work will not have any copyright in that work. So what this means is that the client is free to use that work, because obviously the client will have paid for the creation of that work, but the client is not free to duplicate that work and make further copies of it and sell it for profit. A very common example is, let's say, of computer programs. So when a computer program is written by a freelancer in the capacity of a consultant, and a client requests a certain computer program to be written for their company, so in this situation the client has the right to obviously use that computer program because they're paying for it, but they don't have the right to duplicate that computer program and then start selling it and making a profit out of it, because the copyright in that computer program is going to rest with the original creator and not with the client. However, once again, remember that this is a general rule, but there is a possibility that the client may have requested for the copyright in that work. So in that situation, there will be an official written copyright assignment from the original creator of the work to the person to whom they are selling that copyright. So if there is a written copyright assignment, then even in a client and consultant situation, there is a possibility that the parties may freely enter into a written agreement. So this agreement is basically going to be a written copyright assignment. So it all depends on whether or not there is some sort of an express written agreement between the parties. Otherwise, the general rule is that the original author of the work is going to own the copyright in that work. But if you find yourself in a situation where you are uncertain about what your rights are as an employee, for example, then it's always a good idea to seek clarity about this matter from your employer so that you are both clear about the status of who owns the copyright in the work that you create. And of course, the best way to avoid any confusion at all is to enter into a written agreement which clearly indicates as to who is going to be the owner of the copyright in the work that you create in the course of your employment.